Welcome to Cider Chat. In this episode, we are talking about trademarks. What is a trademark and why it is important? This is part one of an ongoing series on building a cidery.
Going up.
Hello, my name is Rhea Windcaller, and I am the producer and cider MC of this weekly podcast, where we speak with makers, cider enthusiasts, and folks within the cider trade from around the world.
Hip, hip, hooray!
This is episode 255, which means there's 254 episodes already archived at ciderchat.com. So you could just look that up, ciderchat.com/podcast, and it'll bring you to all the archived episodes, which I do consider to be evergreen, meaning that there's always content there, a pearl of cosmic wisdom in each episode. Stories with makers, stories with enthusiasts, all different ranges of the apple to kind of keep it in our sphere. But it's pretty far-reaching, isn't it? Because cider is just an amazing libation. It pairs perfectly with food, so sometimes we talk about that. We talk about places to visit for cider that might include not just a cidery, but sightseeing too. Because heck, up to the pandemic, I was also leading Totally Cider tours, and I hope to do that again, taking folks both internationally and nationally to amazing sights and tastes around the world. So, fingers crossed for the future, eh? If you haven't yet subscribed to this podcast, please do. We'd love to have you on the train out and about to Ciderville. And for all those regular listeners, it's always wonderful to hear from you and to just feel you out there in the world. I do. I feel you. My hands are reaching out to space right now. Oh, it's a lovely time we have. All right, I'm going to take a little pause here, and I'll get to our first announcement of this week. The American Cider Association is inviting you to the 11th year of their annual Global Cider Conference, CiderCon. It's taking place February 3rd through the 5th. CiderCon is taking advantage of the opportunity to debut a virtual event this year that will adapt many of the beloved CiderCon traditions to the virtual landscape. With 3 full days of online programming, highlights for CiderCon 2021 include a virtual trade show and 30-plus educational sessions from cutting-edge beverage, business, and cider experts from all over the world. Some special highlights include Mollusk Busters, a fun-filled session with Greg Peck, Doug Miller, Chris Gerling, and Maria Kennedy, discussing cider mythology. Topics in this workshop will span horticulture, fermentation, marketing, and folklore. Wow, that's going to be like, talk about a packed session. The cider making track has lots of great topics, including a session on carbonation, a session on canning, a session on blending, and a session being moderated by myself, Rhea Windcaller, on fermenting of quince. And I just recorded that presentation last Friday with makers from 3 different time zones. It came out perfect. I'm so excited for that. Tickets are just $95 for American Cider Association members, and there is a bulk pricing available. Visit CiderAssociation.org and register today. P.S. Cider Summit has put together a special tasting kit to celebrate CiderCon that they can ship directly to you. And they're going to have a little virtual event too. So you got 2 little things here to begin with on this week's podcast to be getting ready for. Going to CiderAssociation.org and also CiderSummit.com. So you could have cider to be drinking on hand while you're listening to all these amazing virtual workshops. In Season 3 of Cider Chat, I had the opportunity to speak with Adam Levy. He runs a website called The Alcohol Professor, and they send out a weekly newsletter. So I do recommend that you sign up for that because it's very topical in the industry of cider, wine, spirits, and beer. So you get all bases covered, making the job easy for us, right? He's also the man behind a number of competitions that are securing judges who are retail buyers of that specific products. So he does judging on spirits, craft beer, and cider. And the next annual, it's actually the third annual cider competition, is in New York City. The full title is the New York International Cider Competition, and once again, it's going to be retail buyers who are the judges. The competition takes place on February 21st, and the last day you could get your cider to Adam and his team is the 19th of February. So start figuring that in now. I really recommend going there, getting feedback on your cider, getting some price point measurements that I imagine would help you if you're looking at the market opening in 2021. Certainly we all are. Again, just go to nyicidercompetition.com. It's time once again for the Q&A with Fermentis. And we'll be hearing from Kevin Lane as he helps us maneuver through the question of what medium should you use to rehydrate your dry yeast? Can it be apple juice or water? And should you even do that to begin with?
Hello, my name is Kevin Lane and I'm the Technical Sales Support Manager for the Americas for Fermentis. That's another great and interesting question. Fermentis has worked hard for a number of years testing these two different applications, whether that's the yeast being rehydrated in water of various types, distilled tap water and just mineral water, and then also in different concentrations of the sugar solution, whether that's must or wort or wash. What Fermentis has done is we've created kind of a set of qualities or characteristics that we define ahead of time, and so far with the yeast, it's really about the viability and the vitality, so the amount of yeast, the healthy yeast in the population, and then also how the yeast ferment and the byproducts of fermentation. And really what we're looking for is that there's no significant difference. There's no difference between rehydrating in water or adding the yeast directly to the solution that you intend to ferment. When we run these trials, when we run this analysis, as long as there isn't a difference between the viability as well as the vitality between the different rehydration conditions, and even temperature too, we can label it with a certification called Easy to Use or ETU, E2U. And really what that certification means, if you see that on our package or on a product data sheet or anywhere, if you see E2U, that means that the yeast can be applied in the more traditional way where you rehydrate in water outside of your fermentation. You wait a certain amount of time, you maybe do some mixing just to make sure that all the yeast is rehydrating, and then wait again, and you can add the yeast to the fermenter. Or with the E2U, we found that the same results occur if you add the yeast directly to your fermentation. So in terms of the 4 Saf Cider strains, Saf Cider AB1, AC4, AS2, and TF6, all 4 of those are certified ETU, which means that it doesn't matter which way, or even across a wide variety of temperatures, it won't change, it won't impact the viability of the yeast, and it won't change or impact how the yeast perform, the alcohol level reached, the fermentation byproducts, the esters, the higher alcohols. All of that will be the same regardless of which way you hydrate the yeast. So really what that means for you as a producer is you can take the Fermentis yeast, any of the 4 Saf Cider yeast strains, and you can add them directly to your fermenter if that's what's easiest for you. Or if you're already set up with a rehydration tank somewhere, you can of course rehydrate there, and it doesn't have to just be water anymore. It could be your apple juice, or it doesn't have to be just mineral water free of the sanitizers that are typically in tap water, and it doesn't mean that you can't use deionized water or RO water. We found that, in fact, the water source does not affect the viability and does not affect the vitality of the yeast. So really, if you see the E2U logo, easy to use logo on any of our packages or any of the information, that means that you can take that strain, and it's strain specific, so we've run the analysis on each of the strains. You can take that strain and use it in whichever way you want. Again, you could rehydrate in water, you could rehydrate in a separate vessel with apple juice or water, or you could directly pitch it into your fermenter, and the outcome will be the same in any of those applications.
Easy to use, ETU. I'm going to put that in my next text message out and see if the receiver knows what the heck I'm talking about. I love it. All of a sudden, I feel like an immense amount of decompression. Dry yeast, go ahead, sprinkle away, no biggie. And as long as you're using those SAF ciders from Fermentis, you got it made. If you want to find out more, go to fermentis.com. It's time now to kick off with me a new series on Cider Chat called Building a Cidery. Whether you are already a commercial maker or someone thinking of becoming a startup, or perhaps you are just someone who loves, like me, cider, I know you're going to find this entire series quite fascinating because there's a little bit of something for everyone. We begin the series at the baseline for every business to consider, and that is the topic of trademarks. Kevin Regan will be presenting what is a trademark and why it matters. This was pre-recorded at CiderCon 2020. We'll turn now to Kevin Regan.
So we're going to talk about, what a trademark is. How do you get one? Why is it important? And some practical strategies that you can use as you're developing your cidery and your line of brands to protect your trademark rights and to help save money on potential legal disasters down the road. So first of all, just a little bit about myself. My name's Kevin Regan. I'm an attorney in Seattle, Washington. I've been practicing 15 years, but I actually never thought I'd be an attorney. I started out in the field of science, and in particular botany. So for me, one of the reasons I ended up working with this industry is like my love for going out to vineyards, seeing orchards, learning about the fermentations, about the yeasts, the chemistry involved. So that's something that's really, excited me about this industry. I worked for a while for a federal judge, and so that kind of represents the doomsday scenario. If you're a cidery, that's the last place you want to end up, is being sued by a large restaurant or winery and having to defend your trademark rights. I was also at the U.S. Department of Justice in D.C. As you guys know, this is a very regulated industry, and so there's a lot of other kind of considerations that you might not have if you're just like a clothing manufacturer or another brand that's not regulated. In addition to being an attorney, I'm also an artist, and as an artist, one of the things that's really important is to tell your story and convey emotion, and that's something that's really important about trademarks, and that's the kind of thing that can set you apart in the marketplace. Hiring an attorney can be expensive. Having to rebrand can be even more expensive. One of the themes of this presentation today is that an ounce of prevention is worth a pound of cure. And so there's some simple steps you can take on the front end that can help avoid headaches down the road. And in addition to money, you've worked hard to develop a brand, to get that goodwill in the marketplace. And if you have a trademark dispute emerge, maybe 5-10 years into your business cycle, that can affect your ability to use your brand. You might be forced to rebrand. You might have to enter into something called a licensing agreement where you're basically renting out somebody else's trademark rights. And that company could get acquired, and the new owner could say, hey, we don't want you to license the trademark, and then you have to rebrand. So a lot of the goals about law are trying to increase certainty. Unfortunately, like anything else in the world, there is no absolute certainty, but it's about trying to take intelligent risks and make good decisions. Again, on the economic piece, lawyers are not cheap. If you find a good one, they can bring good value. But again, unlike a clothing company, there's a lot of regulations. Like what you want to call your cider, TTB regulations can affect that. How much alcohol you have in your cider, that can determine whether you need a certificate of label approval, which can affect, the names of your ciders. Cider and wine and beer and spirits, they're very brand driven. At the end of the day, a lot of ciders, they look very similar. The smells may be very similar. And so the consumers rely on what's on the can, what's on the tap handle, what's on the bottle. That's what tells the consumer what they're getting and what they can expect. So I have a lot of clients that have a lot of confusion about what intellectual property is, and it's something you hear about often. But one way to think about it is the idea of property. Maybe you own a house, or you rent a house, or you own a commercial space, or you rent that. It's something that you can use it. It's something you can own. It's something you can sell. It's something you can rent out. And that's basically what intellectual property is. But instead of being a physical place, it's sort of more of a concept. So one of the types of intellectual property is what's called a patent. And so when you hear patent, you think about inventions, right? So if somebody has a new, cross-flow filtration system, or perhaps some new adjuncts to add to, finishing cider, those would be things that you could get patent protection for. It's probably something that doesn't affect most producers, but you never know, especially some of the producers that have a little bit more of a technological component to their production. There might be some interesting inventions. The part we're going to focus on today is trademarks. Trademarks, you can think about the brand names and the logos. We're going to talk in depth about trademarks and how they work. Something else you'll hear about is copyrights. And so under the law, copyright protection is for an expressive work. So it might be for sheet music or the script of a play. It can also be the content on your website. If you have paragraphs of information about different kinds of ciders and somebody comes along and puts up a blog post that's very similar to yours, that might be a copyright issue. Similarly, if you put like Mickey Mouse on your bottle or on your website or something like that, that might be a copyright infringement issue. So things to think about, especially with social media. It's easy enough to make a post without thinking, and you can get yourself into trouble with copyright issues. Something else that you often hear about is trade secrets. And so, the poster child of trade secrets is Coca-Cola. They have this like secret formula, and it's like under lock and key. And so in the cider industry, you might have some, unique ways you're doing business. You might have customer lists, you might have mailing lists, and those are all things that can be trade secrets. And with trade secrets, there's steps you can take to protect those, and a lot of them have to do with like employment agreements. So that's the kind of thing when you're, as you're growing and developing like HR policies, thinking about intellectual property can be an important part of onboarding. So what's a trademark? It's something that you hear people use all the time, and a lot of times they're not quite using it correctly. But basically, if you imagine the grocery store, if you go to like Albertsons or Whole Foods or wherever you shop, it's going to never be the same for you after this presentation. You're going to be seeing trademarks left and right. So whether it's a box of cereal or you're in the alcohol aisle, you'll see trademarks everywhere. And so the easiest way to understand trademarks is to go through some examples, and we're going to do that. But first of all, I just wanted to lay out, 3 of the types of trademarks we're going to talk about. And those include word marks, symbol marks, and what are called combination or composite marks. So let's start out with word marks. So if you're a cidery, you typically have like your main name brand. Sometimes people call it their house brand. So here's some examples of federally registered trademarks. One of them is Avid Cider. One of them is Angry Orchard that we're all familiar with. And one of them is Crispin. And with a word trademark, the owner of the trademark, they actually own that word, that combination of words for alcohol beverage and specifically hard cider. But basically, if Crispin changes the look of its font and the way it's laid out on the bottle, they can do that. They have protection in any font, any format. Same thing for Avid Cider. Any font, any format, any orientation on the label, whether it's something that you're writing on keg rings, writing it onto, the blackboard in your tasting room. Those can all be ways that you can use trademarks, whether it's printed on cans or bottles. And so often one of the best things to do is to try to come up with a house brand that you can get federally registered. So another level of trademark protection is for your proprietary names. So, you might have a special seasonal one that comes around every year. You might have your flagship, semi-sweet or, dry. And those would be things you might want to try to get trademark with as well. So, for example, one of my clients has Cider Hammer for a cider that's got a pretty high alcohol percentage. As I understand it, Walden is kind of a new brand for Angry Orchard, and they've recently obtained trademark protection for it. Persecco, I believe that's woodchuck, but again, these are all examples of trademarks for individual cider names that hopefully become recognized in the marketplace, and you have your customer asking for your specific cider. It can help you stand out on the beverage list at the cider tasting room, and there's just a lot of good protection that you can get. Sort of the opposite of like a word mark is what you call a symbol mark. And with that, your trademark, again, it's telling where this product is coming from. It is a picture. And so, right now these pictures, they look kind of plain. They're in black and white, but this is actually what is registered. When you apply to register a symbol mark, you tell the trademark office, here is what my mark is. So here for Avid Cider, there's this guy, a Titan, like holding the globe. It's shaped like an apple. So it's a chance to tell a picture without words. Similarly, Angry Orchard, they have their kind of iconic, sort of looking sad apple tree here. And these are examples of a layer of trademark protection that you can have in addition to the word piece. And, we're going to talk a little bit about like the worst case scenario, which is a rebrand. And by having like a logo that stays consistent, if you had to rebrand, you could have something familiar that would tell your consumer, tell your customers, hey, this is still us. This is who we are. So a composite mark, it's kind of like a mashup between words and pictures. So this is the Crispin logo over here. Again, you got the sort of tree going on. And you have Fox and Barrel. And here, unlike what we were talking about, where you have protection in any font or format, you're kind of limited to how it appears on the label. So if somebody had similar elements, let's say there's a fox, right? And you got a fox running through the orchard. The owner of the Fox and Barrel, they might have a hard time enforcing that mark against somebody else because, the fox is kind of in a different orientation, it's doing different things. So in some ways, a composite mark is a more narrow form of protection than if you just had the word Crispin or the words Fox and Barrel. Before I came out here, I ran over to the Whole Foods down the street from my office, and I went over to the cider aisle. And, it's kind of a small cider aisle at this Whole Foods, but, you have it kind of running up against the White Claw, some of the beers and all this. And so the consumer comes in there, they're running late, they want to pick up a beverage, and they have to make some decisions. And so this is the competition. This is standing out in the mind of the consumers. Once they love your product and they've got that brand loyalty, they're going to seek you out. But it's the story that you tell through your trademarks that can help encourage people to give you a try. There's that sort of joke about people picking out wine because of the cool animals on the labels, and that's sometimes true with cider. And so it's a chance to put your best foot forward. It's a chance to differentiate your product in the marketplace, but it's also a way to keep competitors away. If somebody starts doing something that's too similar to you, there's different legal tools you can use. The trademark is your chance to defend your spot on the shelf. And as we mentioned, it's something you can buy, it's something you can sell, it's something you can license out. And that's why it's important, even though some of these things are abstracts, you pay money for some tanks and you have a physical thing, you pay somebody to help you register your trademarks. It's not something you can touch, but at the end of the day, once you're doing well, your trademark and your intellectual property, it's actually your biggest asset. And that's what you see when you hear about, some of these companies being acquired. Having your trademarks locked down can make your company much more valuable. So the law can get kind of complicated, but the reality is, a lot of the basic concepts are stuff that you learned maybe as a kid, and I kind of like to use this example of a swing set on the playground, So one of the pillars of trademark law is first in time, first in right. So if you're the first one on the swing set, and there's nobody on that swing, you can get on that swing and you're using that swing, and that's your swing, and somebody else might have to wait their turn. It's kind of the same concepts with trademarks. Like the key to all trademark rights is use. Here in the United States, if you're not actually using the trademark, there are limitations to how much protection you can have. And so, a simple takeaway from this presentation is first in time, first in right. And then another concept is use it or lose it. If you have a cider and maybe it's just a one-off and you make it once and you get a registration for it, well, if you don't ever make that cider again, you're going to be in danger of losing that trademark. The concept, it's called abandonment. You're abandoning your trademark. And similarly, one of the things that's very mysterious for a lot of the producers I know is, they're just doing their thing and they get like what's called a cease and desist letter, which is basically saying, hey, your trademark is too close to ours, knock it out or we're going to sue you. And, often it seems like almost like there's some bullying. A lot of times it's a bigger winery, a bigger brewery. But like why they're doing that, it's not they're jerks. And a lot of times, the bigger ones, they'll be kind of sensitive how they approach it because there's potential for backlash in the marketplace. But the idea is that if you don't enforce your trademark rights, you lose them. So it's kind of like the concept in real property called adverse possession, where let's say you got an orchard and somebody starts building a fence on part of, your land over, 10, 15 years. If you don't take any steps to enforce it, that person might actually acquire title to that part of your orchard. So it's the same kind of concept. You kind of want to put up the no trespassing sign, which is a registration, and you want to keep the trespassers away. Again, use it or lose it. So there's kind of like two sort of main avenues of trademark protection, maybe more two different arenas. And the one that people often think about, you hear about lawyers and cease and desist letters, is courts. And, again, I've got background as a litigator. I clerked for a federal judge. And anything involving court, it's not cheap. So that's where you don't want to end up. And again, if you get a cease and desist letter, it's basically saying, hey, you're in danger here. Somebody is taking the first steps to work towards suing you. The courts, especially federal courts, when you talk about federally registered trademark, they have a lot of power. They actually have the power, if they find in somebody's favor, to make the loser, stop using the mark. Courts have this power called injunctive relief, so they can literally require you to take your product off the shelf, require you to destroy your product, which can be very expensive. And there's also the potential for damages. And damages are basically a way to compensate somebody for the harm that's happened to their trademarks. And with I represent a lot of smaller and medium-sized cideries, and so a lot of our strategy is, hey, what can we do to stay out of court? If a dispute comes up, can we find a creative way to resolve it without having to go to court? The thing about court, when you hear court, think uncertainty and risk. As a business person, one wants to have, some sense of what to expect, be able to forecast for the future. And whenever you're going to court, it's a high-stakes scenario. It tends to be a zero-sum game, which is not a good approach in business or in life, but that's why court is a place you want to avoid. And, I did some searching, wasn't able to find too much about big federal litigation involving the cider industry in particular, but one of the classics is sort of a wine trademark issue. And so over in the Napa Valley, you have Stag's Leap wine cellars, and then you have Stag's Leap. And so back in the 80s, there was this big dispute between these wineries, and, they brokered a truce, and everything seemed pretty good. They even had, a special bottle of wine that they made together, and everything felt like good vibes. And then fast forward a couple decades, and Stag's Leap wine cellars, they got acquired by Chateau Ste. Michelle Wine Estates, which is a Washington-based company. And then you have Treasury Wine Estates acquired Stag's Leap. That's like an Australian-based company. And so now they're back in federal court in San Francisco. A lot of money changing hands, or a lot of lawyers, charging lots of money. And that's a situation you want to avoid. So for a lot of my clients, the place where, a lot of the action is actually at something called the U.S. Patent and Trademark Office. And so you sometimes hear the Trademark Office or the USPTO. It's all the same thing. And that's where you go if you want to get a patent or if you want to register your trademark. Basically, the USPTO, it's kind of a gatekeeper about who can register the mark. And when you register your trademark, there's a lot of, we're going to talk a little bit about those, but there's a lot of legal advantages that you get. And so the basic idea is you have this idea for a trademark, and maybe it's something that you want to use, or it's something you're already using, and you can apply at the USPTO. And what's going to happen is after you apply, 4 months go by, nothing happens, and then they have what's called an examining attorney, and there's somebody that sort of picks up your application, and they're going to do a search, and they're going to say, hey, are there any other trademarks that are confusingly similar to this application? They're going to compare you to any other alcohol beverage that's in the marketplace, and they're also increasingly going to compare you to like bars and restaurants. They do a search, and they think you're too close to somebody else, they won't give you the trademark. And at that point, there's some legal options you can do to try to convince them to give you the trademark. Or alternatively, they're going to say, hey, you're good to go. You can publish. And what happens at that point is your application gets published, and there's kind of a 1 month window where somebody could come out of the woodwork and challenge your trademark. Try to say, hey, trademark office, we're using this first. We're too close to you. We're too close to them. You shouldn't give them the trademark. And so that's just increasingly a lot, for newer companies, that's where the action is figuring out who gets the registration. So just as some examples of like what's going on. So I did a search at the USPTO. So you have these two companies. You have a platform cider company, and they were able to get a registration, right, for this composite mark. You got the word platform. You have a light bulb here with a little apple in it. It's pretty cute. And then you have Bottle Logic Brewing, which is a brewing company. So they're kind of fighting out about like, well, who has the rights to use this light bulb? Are these two things too close together? Should platform have its registrations yanked because of this logo? And so that's kind of what the legal dispute is. So we've talked a little bit about this idea of likelihood of confusion. And this is where I think a lot of people kind of get wrapped around the axle. But basically, whether you're going to court to sue somebody, or you're trying to get your registration at the USPTO, or whether you're trying to cancel somebody's trademark, the test, it's likelihood of confusion. It doesn't necessarily have to be actual confusion in the marketplace. It doesn't have to mean that you have an angry, beer customer calling you up saying that, your beer tastes really weird when it's in fact a cider or something strange like that. You don't need that kind of situation. It's just that potential for somebody to get confused. And so it's like there's a 13-factor test, right? But to tell you the ones that really matter here is how close are the marks and how close are the goods. And, I know this seems really unfair. And, if you're going to court, if you're a cidery and you're duking it out with a distillery, there's some arguments you can make. Like, hey, these guys are high-end whiskey, we're cider, we come in cans. There are those arguments you can make, but those don't fly at the U.S. Patent and Trademark Office. They're going to treat any alcoholic beverage the same. So that means if you're a cidery coming along and then somebody's got a registration for a whiskey that's very similar in its name, that's going to be a problem for you. And so, that's why it's good to do a trademark search and figure out what's going on in the alcohol beverage space. And, under the law, if somebody has like a bar or a restaurant, sort of the rationale of the law as well, like, let's say Emerald, right? You got this like famous chef. Okay, well, maybe he's got, a chain of restaurants and now he's going to start doing wine. And so it's this idea that he's got the registration for the restaurants. So under the law, it's like, oh, well, he might want to expand into wine. And so that's why you have to kind of worry about some of this stuff. And so again, that's the factor about the similarity of the goods. So as another example, right, you have Crispin, which is federally registered for hard cider. But then you also have Crispin, which is federally registered for like software technology. And so under the law, it's like, software on the one hand and, cider on the other, pretty different goods. You're not going to have a problem. The two can coexist in the marketplace. There's some other factors, like about purchase price, right? So if you're like, let's just say you're selling 750 milliliter bottles of cider, let's say it's, some nice stuff. It's like natural. It's, $17 a pop. And then you get into a dispute with like high-end, Scotch whiskey. There's like arguments you can make. Hey, we cost $17, they cost $200. Again, that might fly at court, but it's not going to fly at the USPTO.
That was Kevin Regan. Next week, we'll be hearing from Kevin as he talks to us about how one can secure a trademark. One more note about Kevin's presentation. He was referring to a PowerPoint throughout, and I do have the PDF file to that PowerPoint, and you could download it for free at the Cider Chat Patreon page. Just Google Patreon, spelled Patreon, and Cider Chat, and it should bring you right up to that post. And it will help you both for this episode and episode 256 when he begins to talk about how you could secure a trademark. So quite informative. And hopefully while you're there, you will become a patron too. And speaking of patrons, I just heard from a new patron by the name of Zach, and he wrote, I've been enjoying listening to your podcast. I have a long drive to work every day and have been cranking them out. I found your podcast through the Facebook group Hard Cider Appreciation Society in early November and decided to start at the beginning. I'm currently on episode 99. Now, I received this email on December 30th, so I bet, Zach, you're a little bit further into the 100s now. And, that's the cool thing about all these conversations. They're very evergreen, and there's a lot of info that will just never get old. And so cool on that. Anyways, he continues on with, my cider journey began a few years ago when looking for something new to drink. I've never been a beer drinker, but have enjoyed a little wine and spirits. I started with woodchuck ciders and whatever I could get my hands on in my area, which isn't much, but the big producers. When we travel, I look for local cideries that we can check out. My wife and I took a cider tour up to Michigan this year and checked out 12 cideries. Oh, that's wonderful, and they're pretty easy to find there, There's a whole flank of them. Wonderful. Anyways, I don't necessarily like one particular style, although I gravitate towards dry. But I also like a lot of sweet ciders. Just depends on what I'm feeling. Totally get that. Yep. I'm going to buy a press this coming year and hope to try my hand at making some cider. I've been reading several books this year and trying to consume as much information as possible. I'm glad I found your podcast and look forward to listening. I wish I would have found it sooner. Thank you for what you do for the cider community. Thanks, Zach. Oh, Zach, that's so awesome. It's great to find out how discoverable the podcast is. And, it's been out there for a while, and I've been posting every Wednesday to Hard Cider Appreciation. But I really rely on folks like you to let your fellow cider friends know about the podcast, because they'll probably be in that same position, and looking at over 250 episodes can feel like daunting, as good as they are. So I want to keep you in the loop. And thanks once again for becoming a patron of Cider Chat. It really helps keep cider going up. And Ciderville, I leave you here. This is Real Wind Caller signing off for now. Looking forward to seeing you in Ciderville.
We like cider, we like ponds, we love orchards and having fun. There is a reason why we do it like this. Oh yes there is. There is a reason why we do it like this. Oh yes there is. There is a reason why we drink it like this. Oh yes there is a reason. We like walking through the orchards, dancing in the streets, smelling all the blossoms, kicking up our feet. We like cider, we like ponds, we like orchards, having some fun. There is a reason why we do it like this. Oh yes there is. There is a reason why we do it like this. Oh yes there is. There is a reason why we drink it like this. Oh yes there is. There is a reason. We like walking through the orchards, dancing in the streets, smelling all the blossoms, kicking up our feet. Oh yeah. We like cider. Oh yes we do. We like ponds. Oh yes we do. We love orchards, having some fun. There is a reason why we do it like this. Ba-da-da-dum. There is a reason why we do it like this. Ba-da-da-dum. There is a reason why we drink it like this. Ba-da-da-dum. Ba-da-da-dum. We like walking down the orchards, dancing in the streets, smelling all the blossoms, kicking up our feet. Oh yeah. We like cider. Ba-da-da-dum. We like ponds. Oh yes we do. We like orchards, having some fun.
It's just the truth.
Yeehaw!